Warning: this video may contain strong language, adult themes, and humor, chaos, and fun times. Viewer discretion is advised.
Some sheens. Some food. There, Mr. Honor Howard. Hauser.
I could smash some ribs.
Did you really call him the Honorable Hauer?
No, what?
Somebody said Hauer instead of Hauser.
Oh, weird. All right. Just gonna take a quick little snack.
Yeah.
Okie dokie. So I don't believe his written statement is present yet. So we'll go ahead and give him a little bit more here to... Oh, boy. Hold on. My fingertips are fuzzy. Give me a second. Okay, so is everyone like up to date on what transpired in PC 1033, right?
Oh yeah.
All right.
Yes.
So someone want to speak up for the class and just give us a big old rundown as while we're waiting on this written statement. I'll see if I can prod it out of him.
Would you prefer just to read the minutes?
Minutes or
the court
recap?
record?
Entirely up to you.
TLDR, maybe.
Shoot, a TLDR will work too.
Well, I mean, let's be real though. Whenever we look at stuff, we need to look at the totality of circumstances, right?
Correct.
So, if we advocate for that in our courtrooms and we don't do it ourselves here in this room, then we're not doing justice. So I think it would actually need to be the entirety of the conversation needs to be read.
That's entirely fair.
To give a breakdown, and I think this is okay to break down. There was a motion that was put out to PC 1033 to Judge Hauser. That motion was denied, and that was for the defense to receive the Brady material. And that's kind of where it starts off with.
And for clarification, that was done prior to the probable cause being heard.
That is correct.
And so I'm just going to read from there. So Judge Hauser said denied at this time. Hunter Brown asked, can I have a reason? Judge Hauser replied back, the court will review the matter when a hearing is officially scheduled. The court sees a subpoena as unnecessary at this time, as we do not have the chance to review anything. Mr. Shackle stepped in and said, sir, I don't think the trooper is here, but SAST policy would dictate the report and all evidence compiled should be ready by no or within 24 hours, I believe. And there's something wrong there. Anyhow, Hunter Brown replied, Your Honor, the defense, given this is a criminal matter, has a right to see evidence before a PC hearing is conducted to construct a defense during the PC hearing. Making the defense wait until the court has reviewed or until the day of is a gross violation of the rights of the defense. I respectfully ask you to reconsider or recuse. Judge Hauser said your request is noted and still denied. Also to note, Mr. Castle is correct. We are still within the courtesy period allotted to SAST. Mr. Brown said, in that case, we will not enter a PC hearing until we have enough time to review evidence. However, we are still free to FOIA the records. Then somebody else came in, James Jones. Can somebody clarify who that is?
He would be co-counsel on this case.
Okay, co-counsel. So James Jones said, while Captain Castle is correct, signing the subpoena would not negate the grace period. You are well within your power to sign the subpoena within the 24-hour mark, thus granting 24 hours for compliance. Judge Hauser said your presence at the PC hearing is not required. You are still free to FOIA. SAST is still within their rights to deny such a request. Mr. Jones, you are correct. I could sign now, and it would go into effect at the 24-hour mark. However, this bench will not take such action as we still feel it. Or let me rephrase that. We will not take such action as we feel it is not in the best interest of justice. Then Hunter Brown said, we will foil the records. By we, I mean we will motion to continue if we fail to have enough time to review all evidence before the PC hearing. And Judge Hauser replied, as is your right. The police report was posted at that time. And then Hunter Brown said, can we get that body cam link? Body cam link was posted or was submitted to the court by Mr. Mr. Castle. Hunter Brown said, thank you. And Judge Hauser said, brought in the LEO prosecutor, and that is Joseph. What's his last name?
Joseph
Brian, thank you. I don't think that's important to this. Then Judge Hauser said at this time, PC hearing will be scheduled for Saturday the 7th at 8 p.m. Eastern Standard Time. Hunter Brown said that's fine with me. I'd like to request the court now that we are starting to get some evidence to now sign my subpoena for the other pieces of evidence the defense may need. So this is the third time he has asked for it to be accepted. Judge Hauser said under review. Judge Brown said, Your Honor, to further clarity, this will mainly pertain to witness statements collected by law enforcement. Since we have body cam footage and arrest report, I could likely FOIA these statements, but I would rather go the route of having official records via the court, since they did have to follow proper custody of record rules due to this being an ongoing case. Mr. Bryan said, Your Honor, just to clarify the procedure posture at a probable cause hearing, the state is required to only present sufficient facts to establish a probable cause. Full discovery is not required at this stage, and the defense is entitled solely to the charging documents and the probable cause basis relied upon by the state, which is the body-worn camera footage already provided and referenced in the report. Hunter Brown said, no, the defense is entitled to all documents to prevent the case from growing legs at any time that could do that is able to be used by the defense. I'm also not requesting anything further than what's already being used. Witness statements were collected, so we are privy to those. Judge Hauser said, allow me to be clear, what's under review is if your motion is prudent at this stage. Hunter Brown said, I'm aware that we as defense are allowed to request the current moment. I'm not new to criminal procedures that are followed within the American judicial system. I'm aware we aren't in discovery, but I'm aware of the rights reserved by defense attorneys compared to prosecutors. Judge Hauser said, as a PC is based on the report, you are only entitled to that information for the initial hearing. If PC is found, it must be presented during the discovery phase. If PC is not found, you may submit a FOIA request to SAST. At that moment, Hunter Brown said, Your Honor, with all due respect, the court's assertion that this request is premature or unnecessary is a staggering departure from the fundamental principles of criminal procedure. To suggest that the defense is not entitled to vital evidence simply because we have not reached a specific discovery window is to treat the Constitution as a calendar rather than a mandate. Under Brady v. Maryland and its progeny, the prosecution's duty to disclose exculpatory impeachment materials is an affirmative, self-execution obligation that exists independently of any formal discovery phase. This duty is triggered by the initiation of the criminal proceeding, not the convenience of the court schedule, and it certainly does not pause while my client's liberty hangs in the balance during a preliminary hearing. Furthermore, the court's attempt to gatekeep this evidence based on the perceived lack of necessity is a direct overreach into the defense's Sixth Amendment right to effective assistance of counsel. It is not for the court nor the prosecution to decide unilaterally decide which preliminary evidence is relevant to our strategy or the determination of probable cause. By withholding these records, the court is forcing the defense to proceed in the dark, effectively turning what should be a fair adversarial process into a hollow formality. We demand the immediate disclosure of all material evidence to which my client is constitutionally entitled, and we ask that our standing objection to any continued suppression be noted for the record as a violation of due process. Should this court continue to operate on its own schedule and ideas instead of established law, we will have to escalate this to the respective authorities who oversee judicial operations. So again, I ask you to reconsider and sign the subpoena. Judge Hauser replied, I have reconsidered. My ruling will stand. And Hunter Brown's response was very well. Judge Hauser said, I will discuss your grievance with the panel of judges. However, my rulings are not typically subject to review. Hunter Brown then replied back, perhaps you don't see eye to eye how criminal law procedure works. But as a person well-versed in it and having practiced for some time, this is the wildest stance I've seen from a judge presiding over a criminal case. I understand you will make a determination based off of what you have in front of you. That doesn't make the defense's right to obtain all matters of the case any less relevant. It is not at the whim of a judge, you or another. It isn't at the whim of a prosecutor, either public or within a police agency. It is constitutionally required, at least when the Constitution was the supreme law of the land. Don't waste your time with a review since it won't change your stance. One last thing, you shouldn't preside over many cases if you are the last stop in order. You should be prepared to handle appeals from judges, but nonetheless. Hunter Brown said, I believe there was an objection to Mr. Kane being present as a prosecutor. And then Frank Castle said, Colonel Sanders played a direct role in the charges filed. I don't know how else to communicate this to you. Then laughed, and Kane is tied directly to the target in me within that department. And that this time is when Judge Hauser held him in contempt. Any questions? Anybody want clarity on that?
Okay.
To be
Okay,
clear, is that first time I had held him in contempt, it was simply a $10,000 charge. He then went on to speak more and say that he would not pay the charge. So then he was told to turn himself over to the bailiffs.
It was also at this time that they elected to go to another judge, Judge Bradley Ado, as well.
Which he had another thing that he had something to say about that. He was not exactly pleased as that they attempted to circumnavigate the authority granted to the bench.
So I think there's a couple of key pieces in there that kind of need to be relayed again.
Okay.
The first one being we demand immediate disclosure of all material evidence, where he starts there. So this was yesterday at 8:41 p.m. And he says, should this court to continue to operate on its own schedules and ideas instead of established law, we will have to escalate this to the respective authorities who oversee judicial operations. It is his right to do that, but to threaten to bring somebody else in, I think would be contemptuary in its own right. That is my belief on that.
I would second that.
The next thing would be yesterday at 9:08 p.m. He basically says, I have a lot of history in practicing law, and we may not see eye to eye on that. But he says this is the wildest stance I've seen from a judge presiding over a criminal case. So basically saying, again, you're wrong.
Who wants to be first to provide their feelings on that? Want to start down there at the other end?
Yeah, sure, we can do
I
that.
was just about to say that.
So, pretty much my statement on it would
Be sure to speak up. Sorry, I'm kind of hard of hearing.
Yeah, the situation that I notice most, the argumentative comments, overall disrespect in the court, and threats to a counsel for oversight is definitely contemporary and does violate the court rule of contempt. So that's my personal belief. When you make arguments that you're going to bring somebody else in to overstep the judge on case, and then you are also very disrespectful, saying that you do not see the eye to eye and that you are doing it wrong, that is very argumentative and disrespectful to the judge on site.
Yeah, I kind of have to agree. This is basing everything before, because I know that I believe you were working on issuing your contempt decision when everything happened, when the two other attorneys were added to the docket. He was extremely disrespectful, threatened to go above your head. Couldn't really name who he was going above your head to anyway. And the other thing is this is prior to the probable cause hearing. So essentially anything said in those dockets is to be taken as if they're sitting in front of you in the courtroom, right? So this would be an arraignment hearing, and you had already just told him that his motion was denied. He continued to beat that dead horse over and over and over again. So even if we don't find that his comments were disrespectful in nature, he still violates B of the contempt of court charge because he was disrupting a court proceeding. I do think that we do find disrespect here, though.
I would agree. Disrespect is definitely key here, both on the docket wise and in the courtroom. Even the actions of his direct counsel wanting to overstep me and go right to you for a habeas corpus hearing, coming into your chambers and doing that shouldn't have been allowed, and he was just trying to beat the dead fish there the whole time.
So, my first thing I would like to ask you, Judge Hauser, is why was a warning not issued to him before he went off on started going deep into his tangent?
Honestly, that's mostly a failing on my part. I thought that he would pick up on the repeated of telling him no, that it's not to be appealed at this time, it's not reviewable at this time. I thought that he would pick up is on the matter is closed. Is issuing the fine, I thought, was a sufficient enough warning to be like, hey, you should calm down. That apparently only seemed to enrage him more.
Okay, Thank you. That's one thing I wanted to clarify, because I did note that there were that the other legal counsels in this case began receiving warnings, and he was versus Mr. Brown was immediately given the contempt of court fine. So I just wanted to get your reasoning behind that for everyone here. As for when he goes into that rant, the moment he started going into the rant that is noted at 8:41 p.m. yesterday, I find that immediately is grounds for contempt of court. Just the argumentative behavior, the demeanoring comments he made throughout his arguments. Hunter, shh. I feel that it is reasonable that he was issued the contempt of court.
One thing I'd like, I mean, I kind of already said my piece on what I thought was more contemptuous. One thing I would like to bring in is, at Cornell, they do have a great law dictionary over there that I do use quite often. Their definition for contempt, contempt of court, also referred to as contempt, is disobedience of an order of a court. Additionally, conduct tending to obstruct or interfere with the orderly administration of justice also qualifies as contempt of court. A party that fails to perform a specific act in accordance with the judgment of a court can be charged with contempt and subsequently penalized. The purpose of recognizing contempt of court is to secure the dignity of the courts and the uninterrupted and unimpeded administration of justice. I feel like that it actually hits on all levels of that. So I think the repeated attempts to try to get the subpoena signed was disobedience of the order. You had ruled multiple times saying no, it's denied. I think that it obstructed the administration of the judicial system. It held back on, what needed to move forward, which was the probable cause hearing. And I think that I think the totality of it, it kind of takes away from the dignity of this court. Especially that it kept interrupting and kept impeding the court to move forward.
Aries.
Okay. I was just making sure he was done.
Yep.
I didn't want to interrupt. As far as currently I have one question for you, Your Honor Hauser. My question is, was Mr. Brown in the exercising as a lawyer or as himself or representing himself in that case of 1033, or was he the person that was being charged with the potential crime or case that was involved?
He was there as a attorney for Captain Castle. Sorry, Captain Castle.
Okay. And was he the only lawyer that was representing him, or was there another one that was with him?
I believe he has two additional ones. James Jones
And Robert Holder.
Thank you.
James Jones was present last night. He was the one demanding the habeas corpus hearing.
Sir, can you possibly speak up with your big voice? Sorry. Hard of hearing.
Sorry, for some reason it's not working. So James Jones was present in this room while Mr. Brown was in the custody of the bailiffs. During this point, he demanded a habeas corpus hearing be heard due to the actions of Judge Hauser.
Understood.
And when advised he could not from me, he demanded to speak to Judge Hauser in his chambers while Judge Hauser was filing the arrest affidavit for Mr. Brown.
Understood. Okay. And before this actually ensued, was there anything of a conversation before this set PC of 1033 happening, Mr. Honor Hauser?
I'm so sorry. Can you ask your question again?
Yeah, of course. So, before PC 1033 was opened, was there any prior conversations or prior interactions with Mr. Hunter Brown?
Think when I hired him?
Yeah, I
That's
was
it?
actually
No,
I was actually there
saying
the day that
before
day as well,
this
but
case got opened, was there a prior interaction or a prior conversation about a potential case of this statue or a potentialness of this?
Nope.
As far as I'm concerned, I think the only thing that I would have to say on it is the contempt in court should have happened sooner than later. But I still stand that it's correct that contempt in court was valid in this case, as well as the fact of just blatantly not respecting the court's wishes or the orders of you, Honor Hauser, as well as the rest of the court.
I think the biggest thing would be not giving warning. I think that warning could have been given, possibly should have been given, but at the end of the day, he is an officer of this court. He knows the rules, or at least he should. And I find that I kind of struggle with that one myself. I mean, I've been held in contempt of court before by Hauser as well, so I get it.
Have I?
Oh yeah, my very first case. And then you rescinded it.
I was about to say, I seem to so
you rescinded it, but I did get you did hold me in contempt.
Contempt of court is not one that I give out lightly or frequently. I think there's only been one other person to get it, and that was a Lieutenant Zachary Kane.
I definitely deserved it.
My trooper twink, I smacked him. Is with it. He.
Yeah.
Yep.
Oh, I was Bulldog. Yep.
Did you get the full arrest, or did
it.
you just get the citation?
Oh no, he actually dropped it after the fact, but you still smacked me with it.
Yeah.
But I deserved it. I absolutely deserved it because it was, and to be honest with you, it was a similar situation. You had denied a request that I'd made, and I was like, "No, Your Honor, like, look, this is what I'm trying to do," and you ended up, yeah.
I am fairly positive the only one I've given it to, and it stuck, was Lieutenant Kane. Yep. He had
I remember that.
I believe it was he had walked into a courtroom that he was not invited into.
There's that one, and then he got hit with it 3 times. Twice when I was overseeing.
Because I've given it once, and I think he was the only one that I gave it to. That's because that's a crazy sentence to say.
I've given it to...
Shut up. let me rephrase that. It was the only one we gave a contempt charge to, or at least I did.
Oh. Explosions?
Yep, that was not close.
Yeah, it was too close for comfort.
Yeah.
Yeah.
I would
it's
like to
alright.
say as well, like, based off that there was no warning given, a warning is not a prerequisite for any contempt findings. Like, we may
Agreed.
offer warnings as, a discretion warning, but direct contempt could be adjusted immediately or whenever it seems to fit. And based off this instance, the comments were made, and overall, it was even in response to just a disagreement, but it was more of a disarrangement of actions, and that's why contempt most likely was the best suit to go there without a warning. So I do agree with Honorable Halpern's decision on that.
I think something that we ought to do is maybe put something out just as a reminder to all the lawyers, especially some of the newer ones that are coming around. Like, we don't really take into consideration any emotions until PC is found or not found. That way, this is less likely to occur in the future.
And
I
advise
would
them
agree.
to review the court rules and proceedings.
Yeah.
I would like to note for everyone here is that Judge Ado did give a good detailed explanation to Mr. Brown in the case regarding the contempt and why he was given contempt.
He was fairly upset that that we had pulled him away from a nightcap. He was just climbing into bed, and he got a little upset spaghettis.
Oh, Justice Idol.
Yeah.
Judge Ido.
My phone might be off a little bit there.
Yeah, that was yesterday at 11:16 Central, so just after midnight Eastern.
Yeah.
And it is a very good explanation of what it is. And, he does say, pursuant to Rule 120, discovery begins after arraignment, not at the probable cause stage. Officers of this court should understand the rules and procedures of the court before they start to argue. But as we all know, we're not perfect. None of us are perfect.
Now, for this case, it's only the defense and defendant have received either contempt or warnings for contempt, correct?
It would be both counsels. Don't believe one was passed to Captain Castle.
You did say, you did say,
give Captain a
yes,
warning.
you did.
You give the captain a warning because he had, that's when he had mentioned
Yeah, he
Honorable
walked
Bradley
out
Idaho
in the
to go
hallway of the
ahead.
courtroom and started yelling Bradley's name.
Mm-hmm.
Gotcha.
Yep. At yesterday at 9:57 p.m. or 9:56, he mentioned Judge Ado and let's see. You told him, Mr. Castle, the Honorable Ado does not rank me on the bench. An attempt to go around me again will result in your own contempt charge. And then at 10:04, you told him the warning for Captain Castle will still stand, as is.
And I do believe that even Mr. Mayor Shackles was even telling people if they wanted to overstep you, Judge Hauser, that they had to go to deputy, or that they had to go to Judge Ado
That's
during the whole
right.
protest outside.
So
the
now that I've got
offices.
you all here, to be clear, Judge Ado's official title is Superior Court Judge. Just like, as, just to get that out there, regardless of what it may say, is when you check our uh, our managed job tablet. He is a superior court judge. He just assists with the penal code, and so he needs what do we call it? It's elevated permissions, if you catch my meanings. Everybody
We
understand?
get that. Yes, sir.
Yes, sir.
Yep.
Absolutely.
Blended.
I did find it very interesting that James Jones asked that you address Mr. Castle as Captain Castle. I thought that was
tempted.
quite unique.
I was really tempted to be like, unfortunately, his title means absolutely nothing inside of my courtroom, but I chose not to poke that bear.
Exactly.
I was in the same agreement as you.
Nothing good would have come from that.
I would have brought out the big spoon.
A law enforcement rank doesn't mean anything.
Yeah.
It doesn't change your title like a doctor would. Like you know.
Lighting, keep your fucking mouth.
Even if a doctor came into the courtroom and I called them Mr. or Mrs. last name, it's not out of disrespect. It is simply they are in this court for one reason or another. They are addressed by their name, not their title.
The only time that their title would come into play is if they are here as an expert witness or for materials to be questioned about. Because then
a title is just a formality in court, really, at that point.
The only time you would call them by their title is if they're called as an expert witness on it, and it provides on court document why they're considered an expert witness because they have that doctorate for said thing.
They have a degree in that certain area.
Mm-hmm.
Yeah.
Right. But out of the I'm gonna go with it because it's not worth just poking that bear. It's just gonna start a whole thing, and eventually, I mean, to be fair, eventually we will be well within our means to buy all of us new cars with all the contempt charge fines we're gonna be getting. But
yeah, I need a new car.
Well, on that one, I'd like to recommend something.
We're not hitting Grotties. Sorry.
No.
Actually,
on the contrary,
I think he wants to say
where's
T-Rex for all the
Mr.
judges.
What's that?
That?
I think he wants to say T-Rex for all the
Oh
judges.
no, I got my T-Rex. We're good.
Oh, okay. Okay.
Anyhow, I don't even drive my court appointed car. Anyhow, where's Mr. Coleman at?
Mr. Coleman?
Mr. Coleman is currently dealing with something.
Okay. Do any of y'all know, any of you bailiffs, do you guys know, did he go to jail last night? Did he serve time?
He did. I believe he's...
Coleman is coming.
Oh, there's Coleman. Mr. Coleman. So you took him over to the jail last night, correct?
Yes, myself and Bento Seminary rode with Chuck Mann, New Vespucci.
Okay.
Could you speak up, please? Sorry.
Shout.
Yeah, just make sure you shout it out.
There we go. Sorry about that.
That's okay. Do you know how much time he served for his contempt charge?
4 months.
4 months. Okay. I would like to recommend that it be time served and reduce the fine to 0. That would be my recommendation. But I'd like to hear what y'all think too.
Start at the other end with Mr. Label.
Yeah, I believe that the contempt charge, while valid, I believe that we can consider the time served. I believe the fine should stick due to the fact that it was overpowering and was going over the head of the judge on the table. So I believe the fine should stick for that main reason. As he was arguing the charge and the disrespect and overall arguing, trying to get his subpoena signed, even though it's already declared that it will not be signed.
I think the fine should stay even after serving his 4 months because he refused to pay the fine. He again stated that he was not going to pay the fine, among other things in regards to the response that Judge Ido gave.
I would agree. I think his fine should stick, based on his continuous to want to overstep and his verbal statement that he wasn't going to pay the fine in the first place.
So I'm in agreement, but at the same time, I would like for him to give a civil explanation, maybe calm, cool, and collected explanation on his actions, the reasonings behind his actions. Be professional about it. And I think once we do get his statement on the matter, that should be taken into consideration. But as the way things sit at this moment, I believe that he should have time served and the fine should stick. I would also recommend that a statement is made on the case informing all parties involved that this is the one and only warning to all parties that the behavior and comments that have been made thus far will not be tolerated in this court of law or these proceedings. There will be zero tolerance from that point forward, and that all parties need to act in a professional behavior in accordance with the court rules and court proceedings document.
I said my piece.
Honestly, I think the charges stay, including the fines, and I'm in agreement with Emma, with Miss Bus, going forward, announcing and letting everyone understand that the outbursts, the misspoken words within, whether it's in a court's thread or whether it's here in the courtroom or in the jury room or even upstairs, the utmost respect, regardless of the party, regardless of the person, regardless of the judge, must be respected at all times. And that's gonna go zero tolerance without saying. But I believe, his time served, cool. But the charges, everything stays because it was factual. He did break the law by doing with what his actions were from PC 1033, as well as the one that he opened up recently that we changed to the panel appeal. So I would like to see what he has to say, which will have maybe some light, but I hopefully in his statement, I hope that he is cordial and respectful to the courts. If not, then I would motion for an additional charge.
So I think that he did say it in the original case on the record. He was doing it out of what he believed to be was the best interest of his client. He wanted to ensure that his client's Sixth Amendment rights were not being violated, that his Brady, that the Brady obligations were being completed as required by mandate. I honestly think that a lot of this comes down to ignorance for the way this court operates, and being new. And when I was new, I totally feel it. It is a little bit different, but at the same time, ignorance for the law is not an excuse for the law. So, are you guys okay with doing a? Oh, go. You got something to say?
But no, I just read something.
Oh, okay. Are you guys okay waiting for Mr. Brown's response to the court before we make an actual vote on it or take a vote on it?
I am.
My third.
Fourth.
Fifth.
All right.
Sixth.
I think most of us understand where we sit right now, but I would like to see what he has to say as well.
Was there a possibility of him coming in at some point down the road, or is it he's just gonna write a statement and then we're just gonna look at it?
I think it's a mixture of both. Depending on how quick they want us to, depending on how quick we can review this, it might be just a written statement. If not, he will find us, or at least find one of us here and provide a statement.
Okay.
But I do think that that it's going to be a written statement primarily.
Okay. If nothing else, I have an obligation that I need to go attend to.
Following the adjournment of the judicial panel, the following message came in from Mr. Brown. My remarks during the proceedings were not intended as a personal attack, but as a formal recognition of a fundamental legal impasse. When I stated we do not see eye to eye, I was acknowledging on record that a genuine difference in procedural interpretation exists between the bench and the defense. Similarly, describing the court's ruling as an unprecedented stance was an expression of professional surprise, intended to highlight the gravity of a decision that I believe departs significantly from standard practices. Regarding the comments on the court's role, my intent was to address the structural integrity of the judiciary. As this court holds a high-ranking position, I believe it is vital to maintain impartiality towards everyday cases to ensure the appellate process remains untainted and available for future review. Suggesting we move forward rather than wasting time on a reconsideration was an attempt to respect the finality of your decision and streamline the process. While my phrasing was blunt, it was a sincere attempt to protect the record and the balance of the court system, not an effort to obstruct justice. I maintain my position that I have an ethic obligation to advocate zealously for my client and the public, and that these comments were not intended as a direct attack on the judge or the court system. Since this statement, the judges are in final deliberation and review before voting on the outcome of Mr. Hunter Brown's obstruction of justice charge. We'll be back one day.